All right, I think we should be live now. I don't know if we are live, but hopefully we are. We are live. Nice. We made that happen. So, sorry everyone for a slight delay. You may see a slightly different scenery in the background. I'm not actually in Canada right now. I'm in Dubai. It's midnight here. But I wanted to keep my promise and go live and be with you today. And here we are. So let me know if you can hear me loud and clear. And we'll go off of that. Can somebody hear me? Can somebody see me? Do you have anybody? Nick, are we on?
You're live and good.
Okay, I was just waiting for somebody to confirm that they can hear me. All right, cool. So this is going to be a live so I'm going to base it off the video that we just released recently, which was 69 questions about trademarks that I answered in less than 10 seconds each. Well, I try to answer most of them in less than 10 seconds each. A couple of them went over by a couple of seconds. And that was a fun format. And I'll leave you to guess whether the number of those questions was deliberate or an accident. But so in this live, what I wanted to do is go through that list and spend a little bit more time on the questions where I had to compress too much stuff into too little time, and talk a bit more about that. And once I've done this, as always, I'll open this up to your questions, and I'll be happy to give you the answers that you're looking for. So yeah, once again, hello from Dubai, and it's exciting to do a live from here. So, by the way, if you did not watch the original video with the 69 questions, it's in the channel. It's one of the more recent videos that I've posted. I suggest that you watch it. All right, so. And we'll start with the first question, really, because the first question there was, what is a trademark? And the short answer that I gave to that was, a trademark is what gives you the legal right to stop everyone else from marketing similar products or services under a brand similar to yours. And it is really a very short explanation, but I wanted to talk a little bit about the philosophy of the law, really what that means. And today we're actually seeing a lot of good examples that law is law, but law is useless unless you do something with it, right? Like you can see with the war happening, every party's got their own legal interpretation of what's going on, and in the end of the day, it all boils down to who can enforce the law and what's going to happen if they don't, right? And another example that I could think of is like, imagine you got a friend, right? A friend comes over to your house and they steal $20 from your wallet, right? You find out after they leave that they took your $20 and they left. So it's theft, right? And by any law of any country, that would be theft. You know it, they know it. The question is, until you do something about it, it doesn't matter, right? You can be pissed off at your friend, as you probably should be, but unless you decide to either sue your friend or report him to the police, that theft really didn't happen. And something very similar exists with trademarks and really any other type of legal arrangement. So when I say that trademark is what gives you the legal right to stop everyone else from marketing similar products and services under a brand similar to yours, the legal right really is about really about, can you have the legal tools available to you that would allow you to do something about it, right? Whether you do decide to use those tools or not is a different matter, right? So that's the first part of this. The second part about this is that so I went through a few different options of what is not the same as getting a trademark, like getting a domain name, getting a corporation, getting an LLC, all of those, social media profiles, being in business for a long time, and that getting a trademark registered is the only thing that gives you that legal presumption and prove something that they need to prove. You don't want to be the party who has to bear the onus of proving certain things. So with a trademark registration, all you need to do is show the piece of paper that says, hey, this is my trademark, I own it, and that's all you need to do. If you don't have that, then you are the one who needs to prove everything. You need to prove that how long you've been in business. You need to prove how many people know you under that brand. You need to prove where they know you. You need to prove for how long they know you. You need to prove, your sales volumes, your advertising budgets. It's a crazy amount of stuff that you need to prove, and compare that with just showing them one piece of paper. So that goes back to, if it's easy for you to prove that you're right and it's hard for them to prove that you're wrong, you're in a much better position compared to with you having to do all the heavy lifting. So that's what a registered trademark really is. It makes it really easy for you to enforce your rights, right? And going back to that friend example, the friend who stole your $20, imagine you actually do go to court and you decide to sue your friend, right? You somehow would need to prove that they stole your $20, right? It'll be your story against their story, and the judge will eventually believe one story or the other, but it's hard, right? With a trademark, if you got a registered trademark, it's proven that you own it, right? And the only other thing you need to prove is that the defendant is using a brand similar to yours to promote products or services that are similar to yours. That's it. It doesn't matter whether they knew about you. It doesn't matter whether they knew that you had a brand trademark. None of that matters. All that matters is that you own it and that they used it. Done. So that's why we always say that there's no reason in the world to spend a minute of your life or $1 out of your pocket building a brand you don't own, and the only way to own your brand is to get that trademarked. Okay, so the other thing, so the next question here was why should business owners trademark their brands? I gave 3 reasons, right? Make sure that nobody forces you out of your own brand. 2, gives you the ability to stop copycats from stealing your customers, and 3, to build a valuable asset for your business. So again, this was a very quick and dirty way to answer that question. So, but really, that's the 3 things, right? 1, if you have your brand registered as a trademark, the risk of someone else suing you for that and saying it's actually theirs is minimal. It's almost non-existent. Right? It's still there. The risk is always there, but compared to you not having your brand trademarked, it's almost not there, because if they didn't go after trademarking their brand first in the way that you were able to trademark, to get your brand trademarked, it probably means they're never going to sue you. So that's really how that works. The second part is what I covered already, is that when you got a trademark, you can go after them and sue everyone else who's trying to copy you. And three is it allows you to build a valuable asset for your business. So if you ever want to sell your business, franchise your business, license your brand, all of those other things, it would be extremely hard for you to get any valuation on your brand if you don't own it, right? Imagine if, I don't know, Coca-Cola did not own their brand and anyone else could call their drinks Coca-Cola, right? Their brand certainly would not be valued at tens of billions of dollars today, right? So that's the three big reasons to get your brand trademarked. So going to the next ones, I already mentioned that, right? You can't accomplish any of that with getting an LLC. You can't get that with getting a domain name, social media profiles. None of that works. Placing a TM symbol next to it doesn't work. Copywriting your logo doesn't work. Coming up with a name first doesn't work. None of those other things work, because all those other things do is they at best help you give the court the evidence. And maybe the court is going to buy it, maybe the court is going to not buy it, but all of that is you having to prove, saying that, you know what, I came up with this name 7 years ago, and I had a domain name for 5 years, and I had this, and I had that, and the court is going to listen to you and say, all of that is great, but... right? When you have your trademark registered, and all you need to do is show one piece of paper, which is the trademark registration certificate, and the judge will not be able to say all of this is nice and great, because a trademark registration gives you the legal presumption of ownership and validity, which means that unless the other party has proven to the judge that either your trademark is not valid or you're not the rightful owner, then the judge has to take it as a fact, right? And it's much harder for them to prove that you're not the rightful owner, or that's not a right trademark, it's not a valid trademark, because now they have to go through a very difficult sequence of things that they would need to prove as to why you would not be considered the owner of a valid trademark, even though the trademarks office agreed with you when you filed it. All right, moving on. So what can you trademark? Those pretty much the same. Name of your business, or your personal name in some cases, names of your products, names of your services, your logos, your taglines, and combinations of all of those. So I'm just going to give you a few examples so that it's clear what I meant. So name of the business, think of Apple, right? McDonald's. Names of your products could be iPhone, Big Mac, right? Names of your services could be iTunes, could be Mac Cafe for McDonald's, right? So the logos, obviously, well, the golden arch is the bitten apple. The taglines, I'm loving it for McDonald's. Apple doesn't really have a current tagline anymore. It used to be Think Different. And Google had a tagline don't be evil until they dumped that tagline, which is funny. And then, or for Nike would be just do it. And when I say combinations of all of these, sometimes you can have a trademark that has several things in one, right? So Nike, for example, has a logo that says Nike and then has a swoosh under it as a single trademark. There are also trademarks that incorporate the name and the tagline. And so there's a million different ways you can play around those depending on what it is that the public recognizes you for, or that you want the public to recognize you for. Okay. The next question was, when should you trademark your brand? And the answer to that was really as soon as you realize that you have a brand worth building and promoting, because there's no reason in the world to do that unless you own the brand that you want to put out there to the world. And that's really one of the questions we hear all the time. Like, is this the right time, or should I wait? Should I wait until I've made this much money, or maybe I should wait till I have this many customers? All of these external events really don't mean anything, because what's enough, right? When you're starting your business, initially you're like, well, if I can have one customer who buys my product, that will be quite an accomplishment. And then you're like, well, maybe I should get 10, maybe I should get 100, right? I should make $50,000 and then I'm ready. And maybe 100,000. And then when you get there, you're like, yeah, you know what? Maybe 100,000 was a fluke. Let's get to 1 million and 10, right? This is a never-ending story. And I can guarantee you one thing. If you want to play that game of constantly moving the goalposts and telling yourself that you will be ready when something else happens, the one thing I can guarantee you is going to happen: as you grow, someone else will have trademarked your brand, and you'll be having to solve completely different problem, right? Because it's much easier to get your trademark registered when nobody has heard of you, when you're the only one who believes in the value of your brand, and it's a million times harder to do anything about your brand when somebody has trademarked it, because now you have to go after them. You have to spend years fighting them in court. You have to spend tens, often hundreds of thousands of dollars on that fight. And for what, right? The biggest problem is if you're suing someone else who trademarked what you thought was your brand, there's not even any money that you can go after, because the outcome that you can get out of this is they will be forced to stop using your trademark. That's it, right? It's, to me, it's absolutely insane to even consider the risk of having to go through all of this when there's a much easier mechanism available to you, which is just go file your trademark and let it register in due course. Okay. Next question was whether you should incorporate first, or get an LLC first, or get a trademark first. It really doesn't matter. Really doesn't matter all that much. Depending on when you incorporate, depending on when you get an LLC, right? And if it's all a matter of, a couple of days here and there, yeah, I would say maybe get your company formed first, then file a trademark for it. But if it takes you, 6 months to start the company after you started promoting your products and services, then you would start with with a trademark, and then you can assign your pending trademark that you filed in your own name to your company and go with that. So it's not about what needs to happen first. It's about what you do with the actual brand. Okay, so let's take a little pause here and take your questions, because again, there was a lot of questions in the 69 questions video, and I want to make this as interactive as humanly possible. So let me take a little breather. I'm gonna drink my tea, and I'm gonna answer some of the questions in the chat. And by the way, this is really what this live is for, is to give you an opportunity to ask any questions that you've been wondering about, and we're going to go from there. All right, so we got a question from, let me make this bigger. Okay, Vinay Kumar. I'm planning for a product that will take 6 months to go live, worst case 1 year. Should I register now or when? Okay, that's a great question. Funny enough, it's almost the exact same scenario that I covered in a couple of my other videos. So in US, so I'm assuming you're asking about US. In US, the whole process takes on average 14 to 16 months now. Okay, and from filing to registration. So if you're hoping that by the time you launch your product, you will have a registered trademark, then, well, guess what? You're already 10 months too late. So if it's a year from now, then you're 4 months too late, right? So the proper way to do it is to look what all the successful brands actually do, and if you follow some of the trade publications, like for example about Apple, right? Most of the time, people find out about what they're about to launch through their trademark applications, right? And Apple is now trying to be very sneaky about it, because they usually file trademarks in some obscure jurisdictions, and they file those trademarks in a way that it's harder to track them and find them. But never in a million years would a successful business launch a product that has a name that is not yet trademarked, that is not yet filed as a trademark, right? Because they know that if they made the announcement that, hey, we're planning to put this amazing thing on the market and we're going to call it LMNOP, they know that before they finish their announcement, there will be dozens of people trying to file this as a trademark with the USPTO, precisely in order to be able to put Apple or that other company in the position where they have to fight for that, right? And even though the big company would probably win eventually, their problem would be that they couldn't put the product on the market until they've won the litigation. So it's more than likely that they would have to settle, pay you off, or change the name. So it never would you see that happen from a successful company, because they learned it the hard way. So to answer your question is, if you think that your product has a realistic chance of making you any money, if it has a realistic chance that it's still going to be on the market 2-3 years from now, then your best bet is to file your trademark as soon as possible before anyone has heard of it. File it based on intent to use, and then when you launch it, you will provide to the trademarks office the evidence that, hey, it's already on the market, I'm already selling it, and that's how you do it. And the other benefit of filing a trademark sooner rather than later is that you get to learn from the trademarks office. And, if you do your trademark through Trademark Factory, we'll do a trademark search right away, so you'll know even before we file about what's out there. So if you pick the name for your product that you can't have, maybe someone had trademarked something similar, right? Why would you want to know about this? Why would you want to learn about this after you've put all this money, all this time, all this effort trying to build the brand, trying to market the brand, only to realize that you can't have that brand, right? It doesn't make any sense. So I hope that answers your question. Start now and do what every other successful business does. All right. Do we have more questions? Yes, we do. We have a question from Squirrel Attacks Spidey. Okay. That's a sweet shirt. You become such a great dresser. Thank you. That's not well, it is a question. All right. Because I keep telling people, ask me anything, right? Not just trademarks. My wife, I guess, she takes care of my wardrobe, and some of the shirts I find, but usually what happens is, I'll go through if I'm shopping without her, I would just take selfies, send it to her, and she's like, "Yep, nope." So. Funny enough, speaking of shirts, yesterday I was, strolling through Dubai Mall, huge mall with a crazy amount of shops here, and ended up walking into a Versace store and decided to try on one of their craziest shirts that they've put out there. I've got a love and hate relationship with Versace, because pretty much every time I see something that I like, it's always too big for me. I'm a pretty compact guy, and so I put this on. It's way too big, and I still took a photograph, sent it to my wife, and she's like, "Yeah, the '70s called," because it was so colorful. Let me see if I can show it to you on camera. It might be funny. Hang on, give me a second. I don't know how the quality is going to be of me trying to show you the phone with that picture, but who cares, right? That's what lives are for. So let's see. Those are the pictures of the steaks. Almost there, guys. There. Like that was the shirt I was considering. She's like, nah, probably not the best shirt. So anyway, let's go to the next one. Question from Mike Atkins. If you already have a trademark, say lots of cars, and you need to brand under the same name with a slight change, say lots of cars too, what is your opinion? Well, if it's a different trademark, it's a different trademark. You have to file a new trademark application. Same thing happens when you have a trademark registered for a set of goods and services, and you realize that, hey, we have a trademark for, I don't know, apparel, refrigerators, and accounting services, and suddenly you realize, oh, That's a great stuff from your trademark application. You can't make it broader, and you can't materially change the name. So if you file your trademark and there's a typo, oftentimes you may be permitted to correct that typo, but that's pretty much the extent of what you can do. And you can't have multiple variations of your trademark in a single trademark application. So you can't say, well, I want to protect this or this or this or this, right? If you want to protect this or this or this or this, then you have to file this trademark and this trademark and this trademark and this trademark separately. So I hope that answers that question. And again, keep typing your questions in the chat. We're going to get there in a second. And for now, I'm just going to continue with the commonly asked questions that I covered in that 69 questions video. All right. Next question was, where should you trademark your brand? That's a big one because trademarks are not global, right? There's no such thing as a worldwide trademark. You got to file your trademarks and you got to register them on a per country basis. There are mechanisms that allow you to file your trademark at the same time in multiple jurisdictions, but in the end of the day, you're going to end up having your registrations in all of those separate countries. So then, unless you've got, extra money just lying around that you have no better use for, you have to start prioritizing where you actually need a trademark and when, right? For most of us, we do need to make those decisions. And so the rule of thumb that we use is this. Number one, first you file your trademark in your home country. You always start there. Even if it's not where you intend to make most of your money, even if it's the place where you're not going to have most of your customers, you still always start with your home country. Why? Because when you file your trademark in your home country, you get a 6 months grace period during which you can file everywhere else and backdate all of those other trademark applications back to your trademark in your home country. So always start there. Next thing you do, and kind of next layer, is you'd file your trademark in all the countries where you expect to make a lot of money from selling your products or services under your brand. Because if you don't and somebody else trademarks your brand there, then you will not be able to sell your products and services under your brand in those jurisdictions, and so you lose all that money. So our rule of thumb is if you intend to make at least $30K a year in a country selling your products and services, get your brand trademark there, right? Simple as that. Next layer is if you have expenses in a country, whether it's marketing expenses or if you have a branch, especially if you have a branch, especially if you have people working there in office, right? If you're spending at least $5,000 on building your company or building your brand in a certain country, get a trademark there. And last one, number 4, is if you make your physical products overseas, for example, even if you are not planning to sell your products there, make sure your brand is trademarked there, because if you don't and somebody else trademarks it, then you may be prevented from exporting your own products that you paid for to the countries where you intended to sell them. So for example, let's say you're a US company and let's say you make your products in China, right? I know it's a very rare occurrence, almost never happens, but humor me. So you're a US company, you make your stuff in China, you don't sell your stuff in China, you sell your stuff in the US. And in order to sell it in the US, after they've made it in China, they ship it to you back in the US, right? So if someone trademarks your brand in China other than you, then the mere act of exportation from China to any other country by Chinese laws, under Chinese laws, is considered trademark infringement of their trademark, of the Chinese trademark. So they will be able to stop any ships from leaving their ports if they carry counterfeit products, and to them, and to the Chinese authorities, that'd be considered counterfeit products. So that's your 4 layers of where you want to trademark your brand: home country, where you sell a lot of stuff, where you have expenses, and where you make your stuff. So that's that. Let's answer the question from Reynaldo Perez. How many millions of dollars, once a trademark is approved, should I expect to pay in fees per year? That's a great question. That's a great question. I'm just trying to come up with as smart of an answer as the question is, and I'm totally blanking out. There are no annual fees, right? Unlike with patents, where you do have annual maintenance fees, with trademarks, there aren't any. You got to renew your trademark every 10 years. In fact, trademarks are the only type of intellectual property that, in theory, can last forever. As long as you keep renewing them every 10 years, you get the same trademark renewed and renewed and renewed and renewed and renewed. So Coca-Cola has been renewing their trademark since 1892, the exact same trademark, right? The only exception to that rule in the US, you also have to pay one maintenance fee between the 5th and 6th anniversary of your trademark registration. Don't quote me on that. I think it's $450. It's either $250 or $450 or something in between per class of goods and services. So if your trademark is filed in, I don't know, 2 classes, registered in 2 classes, right? Multiply that by 2. That's all you'll have to pay, and that's it. I don't exactly remember what the maintenance fee is, but it's measured in a couple of $100, and you only do it every 10 years, and in US you also do it once between the 5th and 6th anniversary. All right, let's keep going. So Madrid Protocol. Yeah, so remember I mentioned that there is no such thing as a worldwide trademark, but there are ways to file your trademarks through certain international treaties that allow you to file it once, and it goes to a bunch of countries at the same time. So Madrid Protocol is one of those agreements, the main really trademarking treaty used by over 180 countries, if I remember correctly. Most countries are part of it. And the way it works is after you file your trademark in your home country, again, you need to start with your home country. If your country is a member of the Madrid Treaty, Madrid Protocol, then you can file what's called an international trademark application, where you say, I own this application or registration in my home country, and I also want to extend that for the same trademark, for the same products and services in this country, in this country, in this country, in this country, and you basically check off from a list of countries where you could file that trademark. It looks like a dream come true, and in many cases it is, but it only makes sense when you file your trademark in a lot of countries. I would say don't even bother if you're thinking about less than 5. Actually, scratch that. Forget about it if you're thinking about less than 5, and be very careful about going this route if it's somewhere between 5 and 7, right? It only starts making sense after that, because, two reasons. One, there's still fees, right? and those fees escalate. So you start seeing the savings. The more countries you cover, the more savings you see. For example, only doing one country, you're going to pay more to do it through Madrid than by filing there directly. And much bigger consideration is that Madrid Protocol trademarks are dependent on the fate of your home country trademark. So if something happens to your home country trademark for before the Madrid Protocol trademark registers, or even within 5 years after it registers, if your trademark doesn't get approved, if your trademark doesn't get registered, if your trademark gets canceled, it gets opposed, and you lose that. If you don't get your home country trademark registered, then all of those other trademark applications that are pending in all of those other countries, or even if they're registered, they get canceled right away automatically. So, and it's what's called a central attack, right? It's the strategy that sometimes people use when they see that you've got a weak application in your home country and you've got all of those other trademark applications in the other countries. They don't attack your international trademark application. They go after the main one, the home country one, and if they succeed there, then all of them go away like this. So that's the Madrid Protocol trademarks, and the other one was the European Union trademarks. And in EU, you can actually file a single trademark application that will cover all countries of the European Union, and that is it used to be 28 until the UK left. So now it's 27, and you can still file trademarks in individual EU countries, and very rarely it's something you would do. Usually you do that if you can't get the EU trademark. But usually what you would do is you would go for the European Union trademark. And unlike Madrid Protocol trademarks, the European Union trademark is considered a single jurisdiction, right? It's one. So you can actually file European Union trademark as part of your Madrid application. If you want, it's considered one, right? So don't think it. Remember I said 7 jurisdictions, right? Then Madrid Protocol is a good idea. So from that perspective, EU is one. And the other thing with European Union trademarks, they're not dependent on your home country, right? They're considered a direct jurisdiction. So that's what you need to know about the European Union trademarks. All right. So where do we go from here? Do we have any more questions from the chat? Okay, so we got a question from Stars Work. How much is it to get a trademark? Well, that depends how you want to do it. The one part that is constant is the government fees, right? No matter how you do it, you will always have to pay the government their fees, and they're calculated based on how many goods and services, how many classes of goods and services your trademark is going to cover. If we're talking US, you're looking at $350 per class of goods and services. There are 45 classes in total. So what they've done is they've divided all possible products and services into 45 categories, call them classes, 34 classes of physical products, and 11 classes of services. So you pay the government based on how many of those classes your trademark application is going to cover. In other countries, obviously the government fees are different, but in general, it's a couple of $100 per class. And then the variance starts with who does the trademark work for you. If you file your trademark yourself, then the government fees is all you're going to pay. The question is whether you're going to be able to successfully file your trademark correctly so that it gets approved by the Trademarks Office, so that it gets allowed by the Trademarks Office, so that it gets registered by the Trademarks Office. And for example, if we're talking in the U.S., you have to be U.S. resident to even be able to file your own trademark. If you're not, then you must use a U.S. licensed attorney. But even if you can legally file your own trademark, it's usually not a very good idea, because 81% of self-filed trademark applications get rejected by the Trademarks Office, right? So if you are confident that you're going to fall into the 19% that go through without any complications, great. Then that's the cheapest way to do it, right? Assuming your time is not valuable enough, because filling out that form is finicky. I mean, it's not impossible, right? Every single one of our clients, and I've said it more than once, every single one of our clients who uses Trademark Factory to do it is smart enough to figure out trademarking on their own, right? Everyone who is smart enough to start a business, run a business, is probably smart enough to figure out how to file their trademark application. The real problem is you won't know whether you did it correctly until about 6 to 8 months down the process. And if you did it incorrectly, then in some cases you can save it, in some cases you can't. So there's still some learning curve in the beginning to even complete the application. But let's say, all right, you've spent a couple of hours, you figured it out, you put something together, you filed it. You have no idea whether you did it correctly or not. And if you did it incorrectly, then you'll have to respond to the office actions issued by the Trademarks Office. Again, most normal people are not qualified to do that. Again, it's not rocket science, right? You're probably smart enough to read a couple of textbooks and be able to respond to it correctly. My question is that the best use of your time? Probably not, right? So the second option of how you can get your trademark done for you is, we call them file and pray services, the cheap online companies that charge you a couple of $100. You fill out the form on their website, they generate a trademark application that gets filed in your own personal name. Again, you don't get an attorney doing it for you. To the Trademarks Office, you're considered a self-represented applicant. So again, you don't have an attorney, and all you pay them for is to save you the time of figuring out how to fill out the goddamn trademark application. Because the USPTO's website form is probably one of the worst forms you have ever seen, ever used, right? If you have ever gone to a website and bitched about it not being the most user-friendly website, I don't like this form, why is it doing this? USPTO forms, they're probably the worst I have ever personally seen. They're just absolutely horrendous. So the cheap websites, they make that part easy, right? You don't have to fill out the USPTO website forms. You fill out what's supposed to be a simpler form, and those websites use automated software, or they use some cheap labor to populate that form on the USPTO's website, and you got your trademark filed. But in the end of the day, they take whatever garbage you throw at them and they file it. So if you don't know how to do it, they're not going to correct the information that you've given them, and they're just going to file it as it is. All right. So the third option is no, we're still Nick, we're still on the previous one. Yeah, thanks. So the third option is for you to use so the previous, the file and pray, right? Like I said, it's a couple $100 plus on top of the government fees, assuming it goes through. And if it doesn't go through, then you'll have to figure out how to fix it. If you don't know how to fix it, you'll need to use lawyers. They're going to charge you by the hour, right? And that's really the third option, where you don't have lawyers to fix your trademark application, but you have lawyers to start the whole process, right? We call it file and pay, because most law firms, they're relatively competent at helping you file your trademark, and the problem with them is that they make their money not by filing your trademark application. They make their money by fixing the trademark application that they filed for you. And a lot of them now have some sort of semi-flat packages, like, hey, pay us $750 or $1,200, $1,000, whatever the number is. We're going to file your trademark, and then if there's an office action, we'll do whatever it takes to help you respond to those office actions, and we'll do everything you need us to do. You're just going to be paying us by the hour, and on average, trademark attorney in a established firm is going to charge you around $400 or $500 an hour, right? And complex office actions can easily take 20, 30 hours each go, and sometimes there's multiple. So that's the problem with law firms, right? The problem with law firms is not that they're expensive, is that they're unpredictably expensive. So what you thought would cost you $1,000 can easily cost you $5, $10, $15 by the time they're done. And even then, there's no guarantee that you're going to get the result that you're hoping for. So, and there's the fourth option is Trademark Factory, right? The company that I'm the founder of. Of course, I believe that our offer is the best offer on the market, but I'm not the only one who thinks that, because we've got thousands of happy clients who've used our services, and we have a 99.3% success rate. So with us, what makes us different from all of those options that I've just mentioned is that you pay the flat fee that covers everything from start to finish, right? No matter how many office actions there are in the middle, no matter what happens, no matter why it happens, you pay once, and that one fee covers everything. Your trademark will be filed by a licensed attorney. You will have an attorney of record from start to finish. And that's not going to be me. I'm not licensed in all possible countries where we can help you file your trademark. And we use licensed attorneys or trademark agents in all the jurisdictions where that needs to be done. We handle them, right? So they charge us by the hour. And sometimes we lose a lot of money on those files. But the clients never see that. Right. And the other huge benefit of doing it with Trademark Factory is that we have a money back guarantee. So if we file your trademark, we said it's going to go through and it doesn't, everything you paid us, you get back. So to answer your question, how much does it get a trademark? So with us, on average, depending on how many trademarks you go for, how many countries, which of our packages you go with, on average, a new client spends about $3,200 plus the government fees. If you're going for one trademark in one country with our all-inclusive package, you're looking at $2,500 plus the government fees. So I hope that answers the question. And funny, right? So the reason I spend so much time answering this question is because I actually did talk about this in the FAQ anyway, so I would have gotten there to that conversation anyway. So we just switched the order. All right. So I thought there was another question from. Okay, yeah, it's John. I don't know how to pronounce that last name. I'm not going to even try. Sorry. I haven't launched my product. I'm waiting for my trademark to go through before I launch. Is that okay? Okay. Great question. So again, I'm assuming it's a U.S. trademark. your trademark will not register until you can demonstrate to the Trademarks Office that you've started using it, that you started selling it. So if you got your trademark for products, you have to show them actual products bearing your trademark, and you have to show them that those products are being sold. If your trademark is for services, then you'll need to show them that you are offering the service, that you're advertising the service under that brand. So your trademark can get to the allowance stage, but it won't register until you give them that evidence. And so what you're doing is right. So you file your trademark, and depending on what you know about your competition, right? So I'm assuming that you're the good guy. I'm assuming that you didn't steal somebody else's trademark and just try to sneak into the Trademarks Office, trying to get a trademark on something that should not be your brand, right? I'm assuming, again, that you're the good guy, it's your brand, and that you decided to do the right thing, file your trademark, and get it through the Trademarks Office. So what I would do is once you file that trademark, assuming that you've done the proper research and saw that there's nothing out there, you can start launching your product right away. But you don't need to wait. It's really a question of risk tolerance. You can launch, right? So if you're confident, and so I'm being told that actually we filed your trademark. So see, midnight in Dubai, I didn't even realize that. So once we file your trademark, right? If we haven't found similar trademarks out there, you can launch it and not worry about it. If you are worried about, then the next step, where there's a lot less risk, is you can launch after the Trademarks Office has approved your mark, right? So there was an examiner who looked at your trademark application. Typically happens about 6 to 8 months after the filing date in the US. They didn't see any problems with it. There's no office actions, or if there was an office action, it was responded to. They finally approved your mark, right? That's the next stage, at which point it's much safer to launch. The only risk at that point is that someone may oppose your trademark after they've seen your launch and like, oh, we didn't know that John was actually filing this trademark. We didn't know that John was trying to put that product or service on the market. Now we know, and we object. We're asking the Trademarks Office not to register, right? So that's the opposite. That's what opposition services are for. Opposition proceedings are for. So if you want even less risk, then you can wait until your approved trademark survives the opposition period and gets allowed. At that point, it's absolutely safe to get that brand on the market and on the shelves, because again, your trademark will not go from allowance stage to registration stage until you can show the USPTO that you already started selling. All right, so that's the answer to that question. What else we got? We've got a question from Ash K. Is it worthwhile to trademark a domain name? Depending what you're doing with a domain name, right? Like, for example, flowers.com, or 1-800-GOT-JUNK.com, right? That's part of the brand, right? So the .com part, or booking.com, another one, right? They've done it. It's super difficult, especially with generic names like that, and it gets harder and harder. It used to be easier when a .com was something something novel and unique. Not anymore. So I would say what you want to do is you want to look at the name before the .com part, right, or .whatever, right? Is that by itself a trademarkable brand? If the answer is yes, then I would say, yeah, absolutely go get a trademark. Like if you think about it, Facebook and Google, they also have domain names, but Amazon, right? They all got domain names, but they also got trademarks. So they trademark, what do they trademark? They didn't trademark the domain name, they trademarked the brand, right? And sometimes they trademark both, the brand, they trademark the brand plus.com, but they don't look at it as trademarking the domain name. They look at it as creating a portfolio of trademarks to protect the brand. So I hope that answers the question. Okay, what else we got? Yeah, so stars work. What is our success rate of getting our clients' trademarks accepted versus not accepted? Yeah, 99.3%. We have an unheard of rate in this industry, really because of the proprietary approach that we use here. Because everything here starts with a comprehensive trademark search, where we evaluate the chances of your trademark going through. Because we give people 100% money back guarantee on our work, right? We don't want to work for free, right? And we don't want to waste our time, and we don't want to waste your time really on trademarks that don't go through. So we will do all the evaluation before we even file your trademark. And if we see something that we don't like seeing, a similar trademark, or maybe maybe your trademark is generic, or some other reason that would make a trademark not registrable, then we will tell you and suggest that you either look for a different name or that you waive the guarantee. And in most cases, what our clients do is they actually go back to the drawing board. They tweak their brands so that they end up with something they can own. And that's probably the most valuable part of what we do, because our mission as a company is to help entrepreneurs build amazing brands, and you can't build an amazing brand until you own it, unless you own it, right? And so what our goal is not to file as many trademarks as we can and see what sticks. Our goal is to get you to the point when you own it. It's funny because I was thinking about this the other day, that most of our clients really, if they feel that their registration was too easy, it's funny, right? Because it's only too easy because we've done all the heavy lifting in the beginning, and because we filed our trademark correctly, and because we've done all the research correctly. So we want the process to be easy, but it's only easy because we've done the hard work in the beginning. So I hope that answers that question. All right, let's move on with the FAQ. And again, if you have more questions, feel free to put it in the chat, and we'll go through that. So how long does the trademarking process take? Yeah, it takes anywhere from 6 months in some countries. UK is really fast, for example, to 4 years in Canada now. Canada is getting worse and worse every month, and their backlog is absolutely horrendous. In US, it's about a year and a half for now, right? It used to be better, now it's getting worse. Okay. and yeah, and the question there was, why does it take so long? Precisely what I explained, right? The whole process, it's not like some bureaucrat rubber stamping your trademark application, right? You file your trademark. Well, first they sit on it because they've got a backlog, and then once they get to your trademark application, there's this guy or gal in the trademarks office is going to look at your trademark application. He's gonna, or they gonna, whatever, do a their own trademark search to see what's out there. They're going to come up with their own registrability assessment, and if they don't see anything bad about it, they'll approve it. If they do see something bad about it, they'll issue the office action. It takes time to write the office action, and then the applicants got 6 months to respond, and then they got to respond to your response, and there's this back and forth. Let's say finally gets approved, then there's the short period when anyone can oppose, usually a month or two, depending on the country. Some countries it's 3 months, so anywhere between 1 and 3 months. Assuming it survives the opposition period, then it gets allowed. After it gets allowed, there's some post-allowance formalities, then it gets registered, then you get sent your trademark registration. All of this takes time. And unfortunately, there is no way to expedite this, right? You can't pay a little more to the government and say, hey, can we do it in 3 days rather than 3 years? No, it doesn't. And again, it doesn't matter who does it for you. Okay, what do we get? Let's go to the next one. So, Reynaldo Perez. Along the lines of John's question, is it okay to start putting the TM on all of my products and on my website, even though it hasn't been approved yet? Okay, yes. So TM can mean anything, right? It can mean that you've got a registered trademark. It can mean that you've got a pending application. It can also mean that you haven't even filed your trademark. TM means that you want the world to know that you want the world to consider this your trademark. All that, that's all that it means. There's no legal significance to putting a TM next to your trademark. So yes, by all means, feel free to put the TM next to it. It's not going to hurt. It's not going to help legally, but the vast majority of people don't know that TM doesn't mean anything. So they might actually take that TM to mean more than it actually does, and treat your brand as if you own it. So again, there's no harm to it, but don't rely on putting your TM symbol next to your brand and expect it to really protect you, because it won't. Okay, so that's the answer to that one. So I sort of already covered this, but the next question was, can anything be registered as a trademark? And I said no, because you can't trademark something that doesn't fulfill the role of a trademark. A trademark has a very specific role, a very specific function, in that it's supposed to allow the market to tell your products and services apart from everyone else's products and services of the same type, right? It's supposed to distinguish you from everyone else. So if your trademark doesn't perform that function, then it can't be registered. And there are two big categories why your trademark would not perform that function. One is that your trademark is too similar to someone else's previously filed or registered trademark, right? So if someone else already owns a trademark, right? McDonald's, and you're like, I want to start a restaurant, and I want to call it McDonald. I'm just not going to use the S at the end. And let me be creative. I'm actually going to call it the McDonald, right? You file that trademark. Of course, the trademarks office is going to refuse that, because if you were to if you were to operate a restaurant, call it the McDonald, the public would be utterly confused between you and them, and that would not help the market distinguish your products and services apart from theirs. And so that's the one reason you couldn't get your brand trademark. The other reason you couldn't get your brand trademark is if your trademark itself is generic. For example, you're trying to trademark, I don't know, the word burger. If you're a restaurant, you can't trademark the word burger or a hot dog or spaghetti, because those are the words used by everyone in that industry. And trademarks are not, like, trademarks are very different from domain names, because with domain names, all you're trying to do is grab as generic name as humanly possible, and just get the traffic from people who are interested in that generic thing. With trademarks, it's different, right? It's the other way around. Trademarks are all about differentiation, not about genericness. So you wouldn't be able to do that, or descriptive trademarks. So that's the same thing you couldn't do. Now, what else we got? So we talked about this, we talked about that. Let me see. Cover that, cover this. So once again, what you want to do is you want to watch the video. Really, the reason this live came to be is we just launched the video about 69 questions that I answered in less than 10 seconds each. And a lot of those answers, even though they were short, there's more than enough that you need there. So I'm just trying to see if there are any other questions that I wanted to spend a little bit more time. One thing I want to say, with what I just mentioned about your trademarks being too similar to someone else's, the big misconception that there is that all you got to do is just change a couple of letters. That's not how it works, right? It's all about the general impression, right? If it sounds the same, if it looks the same, if it has the same meaning, or even similar meaning, similar sound, similar look, you're going to have a problem. So don't think you can get away by adding meaningless words before and after, like the, or McDonald's restaurant, or McDonald's food, McDonald's burgers. None of that is going to help. So be very careful with picking that name. So we talked about that, talked about this. It's so cool that the questions you guys asked in the chat, they answered, that allowed me to walk through a lot of things that I wanted to talk about anyway. So talked about that. There was a question about annual maintenance fees. So talked about that. Yeah. So really, that's what I wanted to cover in this live. And Nick, do we have any more questions in the chat that I should be answering? Okay. Looks like there are no more questions. That's good. So I will be wrapping this up then. Again, thank you for everyone who showed up. I want to make a little teaser to those who are still on this. Probably tomorrow, we're going to post a video that's it's going to be very different from any other video that I have posted on this channel. Something very personal and something that has very little to do with trademarks, but it will show you something that I had been dreaming of for about 10 years. And now it's that dream has come true. It's materialized into something completely epic. So with that, I invite you to watch that video when it gets published. If you haven't subscribed yet, make sure you do. And I'll see you in the next live. I don't know whether I'll still be here in Dubai or somewhere else, but the plan is to do these every 2 weeks. So when I'm in North America, we do this at 4 p.m. Pacific. When I'm here in Dubai, we do it at noon. And so we'll make the announcement closer to 2 weeks from now. So again, thanks everyone for being on this live. I hope you found it's useful. I know I enjoyed this,